I am going to give you 12 top tips for thinking about when you're doing your committal applications. And when I'm talking about committal applications, I'm thinking all of these matters, apart from the Lovett point, which we'll talk about in a moment, applies to antisocial behaviour injunctions, unlawful eviction injunctions, gas access injunctions, and disrepair injunctions. I kind of started off by saying, what do you want to achieve? I'm assuming, as reasonable people, that what you want to have achieved is compliance with the order. Who really wants to have someone sent to prison? I'm sensing no, but I'm not totally certain. And who really wants a mandatory ground for possession? That's not really a good reason for doing a committal application, is it? The starting point is Section 14 of the Contempt of Court Act 1981, which basically says that the imprisonment tariff is up to 2 years on any one occasion. That is following one complete adjudication of a committal application. And also there is an unlimited amount in terms of a fine that's available under that part of the Contempt of Court Act. I don't think we tend to think about fines because very often your average defendant in an injunction case doesn't have any money unless they've just sued you for disrepair successfully. But unfortunately, if you're a local authority, you might have a lot of money. If you're a private landlord, you might have a lot of money. So fines aren't necessarily first and foremost what we're talking about, but you wouldn't really want to be fined, would you? If you've got a lot of money. So do think about that and bear that in mind when you are about to breach any injunction or undertaking. Starting your committal application, for those of you who do antisocial behaviour injunctions, very often your committal application begins at the time of someone else's choosing, when the police decide to arrest somebody, when the defendant decides to randomly breach the injunction. So in terms of starting off your warfare in terms of the context of committal, it's very often not at your own choosing if you are the person who has the benefit of the undertaking or the injunction. So that's something to bear in mind. You're very often taken by surprise. And you may not have even thought about this case since the last time you got this particular injunction. So this is quite important because it happens randomly, it's not of your own choosing, and there is a bit of the CPR 65.473 and 65.474, which are important things that I'd invite you to have a look at. Following the arrest, the alleged breach must be dealt with within 28 days of the date on which the arrested person is brought before the court. Sounds fine, but actually, probably, you're going to end up getting directions on your first hearing at the arrest. And you want to watch out very carefully that you do not get listed for the determination hearing, which is beyond the 28 days of that particular arrest. Okay, because otherwise the court hasn't got jurisdiction to send your defendant to prison. I've had a couple of good days out on this one, where we worked out that actually the hearing we were at for the trial of the matter was after the 28 days, and effectively we just I explained to the client, and we ended up strolling off hand in hand out of the court without him being sent down. And the other side then had to effectively initiate a committal application based on the issue that had given rise to the arrest. Yes, and that's absolutely fine. You're allowed to do that. 65.474 does allow you to put in a committal application in respect of the incident which gave rise to the arrest. For those people who are organised, the way to start these things off at a time of your own choosing is by complying with Part 81 of the CPR. The current version's been around since 2020. Two top tips that arise from Part 81. The first is it's very prescriptive. When you're using the Part 81 procedure for a breach of undertaking or a breach of an injunction, there is a special form called the N600 and also the N244, which is the Part 23 application notice. And really, if you can fill a form in, you take the N600 and you attach it, fill in your form, your N244, and attach the form N600 to that, and effectively you fill it in, you're going to comply with Part 81. Just so you know, there are things that it must include: the nature of the contempt, the terms of the order that's been breached, whether the defendant was personally served, whether there was a penal notice, and the facts that are going to be relied on in your application for committal. But if you fill in N600, you'll be doing all of that anyway. Importantly, with the N600, you will be telling the defendant they have a right to legal representation, that they should have a reasonable opportunity to obtain advice, and that they have the right to remain silent. And also, it tells them what the court's powers are in terms of committals, fines, etc. So if you fill that form in, you're not really going to go far wrong. Well, I say that, but you know, I get amazed every day about what happens. But hopefully, you'll fill the form in and you'll be absolutely fine. But CPR 81.4 and 81.5 said a moment ago that the process is very prescriptive, and to some extent you've got to do what it says or your committal application is doomed probably to failure. But CPR 81.4 says unless the court directs, the application must be supported by written evidence by affidavit or affirmation. And 81.5, unless the court directs otherwise, the contempt application and evidence must be personally served. Now, hopefully you've all got brilliant process servers. Good. And they will personally serve your documents, and you'll probably be able to get sworn affidavits. But if you haven't used sworn affidavits, or if there are problems with service, then because the CPR 81 does allow you an opportunity for the court to make a direction regarding those two issues, make sure that when you get to court, you've issued an application, or you are going to have the information to put to the judge about why the court should make a direction about, say, using witness statements, or why the court should make a different order about service of the committal application. You can do it, but of course it does require some planning. Lovett and Wigan. The main thing about Mr. Lovett is that he didn't appeal the fact that the judge had given him a committal order of 30 weeks imprisonment. What he stupidly did was he decided to seek to appeal on the basis that he didn't think the judge was right to use some kind of second-hand video evidence, i.e. a video of a video, in order to find out whether or not he'd been the nightmare neighbour that he in fact turned out to be. So he was completely hopeless in terms of his success on his appeal to the court in respect of the committal. But lots of exciting things. This is what happens, isn't it? You know, bad cases, and then they just unpick a can of worms. Lots of principles are restated, but some principles in Lovett are novel and suggest a new emphasis for the courts in how they deal with committal applications. Of course, it's understandable and it's agreed, and it's been so for a long time, that the whole point about committal applications are threefold: ensuring future compliance with the underlying order, punishment for any breach, and rehabilitation so that you can comply with the order. And there are 5 options in terms of sentencing. So there's the immediate order, suspended order with conditions attached, adjourning the sentence, fining, or making no order. Okay. So in terms of custody, the Court of Appeal in that case restated the fact that a custodial sentence should be reserved for the most serious breaches, which is obvious. It's good practice for the court to consider a penalty for each breach and decide whether or not it's going to make those the penalties concurrent or consecutive. But it can get a little onerous, and it may well be that you end up with enormous amounts of schedules and lots of allegations. And it may be that you're going to end up with a gargantuan sentence. And so the issue of proportionality in relation to the totality of the sentence does need to be borne in mind. Otherwise, you could end up with some excessive sentences. Custodial sentence should never be imposed if an alternative course is sufficient and appropriate. And if it is that a custodial sentence is required, then it should always be for the shortest term possible. And if imprisonment is appropriate, the length of the sentence should be decided with reference to whether or not it is suspended or not. That the new emphasis has been underlined by the Court of Appeal. It says a suspended sentence is usually the first means of trying to secure compliance. In many cases, however, the first option will be to adjourn consideration of the sentence. The court can use the adjournment as an opportunity to speak directly to the defendant about their behaviour and give an indication to the defendant what sentence would have been imposed if the hearing wasn't being adjourned, and what sentence is likely to be effectively imposed after the adjournment, together with a clear statement about what the consequences of, in the future, good or bad conduct is going to be. Okay, so that is the sort of thing that makes your witnesses get very cross with you in the conference room afterwards when they find that there's going to be an adjournment of sentencing, because they were hoping that this was going to be it. You've not only got another hearing, but actually it sounds like the defendant's going to be, if he or she behaves, is going to be able to probably not get very much of a sentence the next time you come back. So this is a real issue for managing witnesses and also advising clients about, because it may well be that there is a move afoot, a policy decision against sending people to prison. You can probably work out why that might be, because there aren't enough prisons, and the ones that we've got are absolutely teeming with people. But I think that in terms of managing witnesses, that bit from Lovett is something that you need to, if you haven't already got it firmly lodged, it's something you need to advise clients, witnesses about, because they may get rather cross about the prospect of what's going to happen. I like the fact, for those of you who are in court a lot, and do these. It may well be that someone's been arrested, and it gets sorted out on the first hearing, and the court then decides that it's going to approach the matter in a Lovett way. For drafting purposes, you want to make, depending on where you are, where you stand in the dispute, it may be that you may want to think very carefully about how that is drafted in terms of the warning that's being given for the defendant. Because if you're the solicitor for the defendant, you might want it put in a particular way. If you're the solicitor for the claimant, you might want it put in another way. So that's something that I think you should think about, and it's definitely a sea change in the way that committals are being dealt with. The thing that the Court of Appeal did at paragraph 6 is they effectively imported a report from the Civil Justice Council, and there's this matrix, category 1, category 2, category 3. Gets more harmful the further to the top of the page you get, and culpability. The culpability increases as you go to the right of that matrix. So have a look at paragraph 7. What does culpability mean? It says there are 3 levels of culpability: high level for very serious breaches or persistent serious breaches. Deliberate breach is a B, which falls between A and C, and lower culpability is for minor breaches or breaches which are not so significant. You know what those are in terms of your particular case. In terms of harm, I think it's easier to think about harm. Paragraph 8, the level of harm is determined by weighing up all the factors in the case to determine that the harm that was caused or was at risk of being caused by the breach. In assessing any risk of harm posed by the breaches, consideration should be given to the facts or activity which gave rise to the order in the first place. That's quite interesting, because very often you can think about your committal application as being a separate application. Forget the past. We've got the order, but there may be things in your committal application, and the Court of Appeal says that the judges should consider this. There may be something in your committal application which you think the court might need to know about. So it might be that things are getting worse since you've had the order. When you look back at your old evidence, yes, it may be that this is what's happening now is a repetition of matters, or it may be that they're getting better. So I think that the initial application may well be something you want to refer to, and it may be that you seek a direction from the judge to allow that to go into the committal application bundle. Not that it's anything to do with the actual committal itself, but it is to do with the issue of sentencing later on. So, paragraph 10, the analytical approach based on culpability and harm allows the court to determine a starting point for the sentence and a range within what the sentence can be adjusted by looking at additional elements which increase or decrease the seriousness. Personal mitigation is set out in this part of the judgment. Specifically says examples of factors increasing seriousness include a history of disobedience, particularly vulnerability of any victim, persistent breaches, and mitigating factors might be genuine remorse, ill health, or particularly I like lack of maturity. I recognise myself there. When it affects the responsibility of the defendant. An early admission, as it barely needs to be said, will serve as a significant mitigation factor. So I think there are lots of practical points that come out of Lovett. If you haven't read it recently, I would have another look at it. I think it will help you manage your clients' expectations and or your witnesses' expectations. Now, the other thing that's quite important is CPR 81.8. It says that the court is responsible for ensuring that the transcript of any judgment is put up on the court website, and the court is required to transcribe it and publish it. So a case I like is this case that I put down here called Circle 33 and Kathirkmanathan, which is a 2009 case, which is worth looking at because I suspect what happened was that the landlord thought they put in the usual clause of forbidding somebody from instructing or encouraging or permitting somebody to do X, Y, and Z, which he wasn't allowed to do. And in fact, by the time this got to the Court of Appeal, there were no words for the court to find to say whether or not he was forbidden from allowing or permitting a third party to cause a lot of noise, which is what this case was about. It was just solely all on him, and the only reason I can think that ended up at the Court of Appeal was because everybody thought that they'd used the normal wording that they wanted and had written that in, and they got the order from the judge and they thought, yeah, that includes his kids, that includes his girlfriend, but it didn't. It was just him. And so as a result of that, he did get imprisoned for a short period of time, which is a bit grim. And then the court set the committal aside. But basically, that's really just a drafting point. They thought they understood what their undertaking was. They thought they understood what it meant. And this poor man went to prison for a short period of time. So make sure that you know what you're drafting, and make sure that the court knows when it reads it what is covered. This is quite important. Again, I see you at a very exciting directions hearing, yet again. And in the case of Hammerton and Hammerton, this is a really quite sad case. It was a family case, but it is really relevant. And what had happened was that I think that Mr. Hammerton was representing himself, and the judge decided, because there was a committal application before the court and also a contact application so that he could speak to his son or daughter or whatever, at the same time, the judge thought it would be a great idea to list the two applications together, so the committal application and the contact application. The only problem was that Mr. Hammerton was going to exercise his right not to say anything in the committal application, and a lot of the issues in the committal application were the issues in the contact application, which made it very difficult to actually make any good points in his contact application. So effectively, that was how not to do a committal application when there is an application that's concerned with some of the other issues, the similar issues. So where there's an overlap between the committal application and the other application. So for example, it might be worthwhile if you've got a committal application, but you also are thinking about using a lot of the evidence for your possession application or your application for injunction. I'd think very carefully about how you get those listed, and find a copy of Hammerton and take it with you to the hearing and put it under the nose of the judge, because effectively in that case, all the orders were set aside, and it will have cost somebody a lot of money. It would also have been very distressing, and there was an easier way in which it could have been organised. For example, they could have had the separate proceedings on different days, even with different judges. So watch out, because that's quite important. And I definitely had I hadn't seen this case many years ago when I was a small boy, and the judge said, I'm not going to list the committal application at the same time as the possession case. I'll deal with the committal application first, and then we'll have to deal with at another stage. We'll look at the possession then. Okay. Effectively, what happens when there's a breach? You could just ask the court to decide whether there has been a breach of the suspended committal order. And if that is what you want to do, you can just have that decided on the balance of probabilities. So effectively, the trigger, the only weight of evidence you need to trigger the suspended committal order is on the balance of probabilities. And in fact, you also wouldn't need to prove the breach as you would do another committal breach. That might be something that is appealing to you because it might actually take you a lot less time to get your application together. It might be that the court is going to treat it in a much more routine way, and you can probably get a shorter, earlier hearing. So there are two cases that I referred to there. One about undertakings, which is Alfa, Laval, Tumba, which is a 2010 case, and Phillips and Symes. Tripping the suspension is activated on the civil standard. Villiers and Villiers is another family case, and there are lots and lots and lots of things that were wrong in that case, but effectively deciding what to do with a suspended sentence when a case comes back before you, if you're a judge and you are wondering what to do, it's entirely a matter of the court's discretion in the circumstances, whether or not they activate the original sentence, or what it is that they activate and how they go about it. So effectively, just proving that it's happened doesn't necessarily mean you're going to get the lengthy sentence that you thought you were going to get. They're not obliged to activate the suspended sentence. Purging contempt. This is now set out in CPR 81.10. Effectively, you can ask the judge to let you out of prison if he or she is so minded. The contemnor would have to make an application under Part 23, probably to the judge who imposed the sentence. You have to apply back to the same judge. You'd have to apologise to the court with some credible evidence and prove to the court that you're going to comply with the underlying order that got you into this mess in the first place. So you'd have to have some good evidence for that. I have to say that I haven't been involved in very many applications to purge contempt. Most people who I've advised usually think, well, it's a fair cop. I'll do the time. I'm going to be out in half the time anyway. But in the case of Swindon Borough Council and Webb, on this point, it said this: the power of the court to discharge is discretionary and unfettered, but any refusal to discharge would need to be justified on grounds of necessity and proportionality in terms of the punishment or the coercive end of the original sentence. So necessity and proportionality, but effectively it's a matter of discretion and it's unfettered. Of course, my point 12, section 258, Criminal Justice Act 2003, is that one half of the sentence is to be served before it's the duty of the Secretary of State to release the prisoner. So that's another thing to manage with your witnesses, isn't it? Because they think, yes, a whole 2 years. He's going to be away for a whole 2 years. I'll be able to get some rabbits back, and have a few quiet sleep. But it's perhaps not going to be like that, because they will only serve half the sentence.